Mr. Hivner, on behalf of Judge Bennett and Judge McBrayer, we're pleased to welcome counsel for this oral argument, which we are live streaming to fulfill our obligation to keep our courts open. We will conduct the hearing in the same manner as if we were all together in the courtroom. Each of you has 15 minutes to present your argument, and the appellant may and has reserved some time for rebuttal. Unless either of you has an announcement, I'll ask Mr. Hivner to call the case.
Rachel Victory et al. Versus State of Tennessee.
All right, Mr. Bobo, you have the floor.
Yes, good afternoon. May it please the court, Todd Bobo on behalf of the claimant appellant, Rachel Victory and her minor daughter, Lila Victory. As the court, this honorable court has probably seen in reviewing the facts, this claim occurred as a result of a trip to Timms Ford State Park in April of 2018, where our minor plaintiff, Lila Victory, the daughter of Rachel Victory, was traveling with her grandparents to enjoy the park. She was 5 years old at that time. During their trip, they went to a playground. The 5-year-old fell off a ladder, broke her arm, and then the next day eventually had to have surgery on that arm. So we have filed suit. We filed with the Claims Commission for and included gross negligence. We understand that the recreational use statute applies in this particular case, thus making our burden a lot tougher. In this particular case, we would argue that gross negligence does apply. And when you're looking at gross negligence, it's as this honorable court knows, gross negligence is a conscious neglect of duty or a callous indifference to consequences. So gross negligence also is a negligent conduct reflecting a reckless disregard for the safety of others. And that was stated in the case Rucastle versus State. Also in Rucastle versus State, it states that gross negligence presents an issue of fact. A question of fact must be reserved for trial unless the evidence contained in the record could only bring reasonable minds to reach one possible conclusion. In this case, we would argue that there is a genuine issue of material fact to go to the trier of fact, and that is because I think as in the court file in Rachel Victory's deposition, page 49, she states that she went back and looked at the playground. Granted, it was in July, which is approximately 3 months after, but saw concrete coming out of the ground, protruding from the metal poles that were secured to the ground, saw hard pan, things like that. Our stance, quite simply, is that type of hard pan, concrete protruding from the ground, any rocks sticking out of the ground, can't happen overnight. That would be something that would happen over a long period of time. So our stance is that it was not maintained, inspected correctly, and that by not maintaining it or inspecting a playground, which a playground is an attractant for young kids, would be considered. We would argue that it is a complete disregard to the safety of others. Now, we understand that the rangers stated that they drove by, inspected, put mulch on the playgrounds from time to time. We don't have proof to refute that. And we also don't have proof that there was a prior claim. We know that according to their statements, and they had not heard of any other problems with this playground until our incident report. But having said that, just by seeing that the playground is hard pan, has some concrete protruding, things like that, it would show that that would take a long period of time of not maintaining and not inspecting in a good manner, in a reasonable manner, and that we would argue that that is gross negligence. The trial court in its order compared this case to Waterhouse, which is the case where an individual was walking back from the boat ramp. and to picnic and stepped in a hole. And that hole was covered by grass, and there were other holes that had been filled with concrete. And I understand why the court stated that that was not gross negligence in that particular case. I would argue that this case is distinguishable in that this is not a hidden hole. This is a playground out in the open that should be maintained and inspected. It is.
What was the testimony about the condition of the playground the day of the accident?
The testimony was that it lacked mulch, and that was from the grandparents. So it wasn't until, I guess, July that our mother went back and checked it, and her testimony on page 49 of hers is that states the grounds were terrible, like we saw protruding concrete coming out of the metal poles that is secured to the ground. And that's in Rachel Victory's deposition on page 49.
Yeah, I understand what she said 3 months later. I was wondering what was
Yes,
said the day of.
and we understand that is a stretch. Our stance is that even within that 3-month period, there can't be enough erosion to where there is complete hard pan, concrete protruding from the ground, as she's testified in her deposition, or any rocks protruding from the ground. So, and that's why that's our argument on that, Your Honor.
Thank you.
As far as the Rewcastle case, which is the case that we rely on, there was a prior complaint there. I understand that's the distinguishing event that the court used. However, we would again argue that the playground, if hard pan, that can't just happen like that overnight. And in the court's decision, I think under footnote 5, it noted just that. And then that the defendant's knowledge of the defect, along with its failure to remedy it, was sufficient to potentially allow a reasonable jury to conclude. Again, we would argue that if these rangers are inspecting as they say, then they would be able to see this. Now, also in the court's order, on footnote 7, it talks about our response to defendant's request for admission, stating, in reviewing the photos, there were rocks and pieces of concrete showing above the surface. These photos reference do not depict any visible rocks or concrete. Even assuming the alleged rocks or concrete are present but difficult to see in the photos, such rocks or concrete are small and benign in contrast to a rusty cable. So they're distinguishing it from Rewcastle. We would argue that that at least shows a genuine issue of material fact with relation to the flooring of that particular playground.
In this case, did our 5-year-old child fall on the exposed concrete or on dirt?
On the hard pan. So
Hard pan as in dirt.
as in dirt. Yes, Your Honor. So
Okay.
yes, I keep going back to the protruding concrete or rocks. That did not make contact that we know of with our child. That just would show we would argue a complete disregard for maintaining or inspecting the flooring of that particular playground. And actually, that's my argument.
Okay. Anything further, Mr. Bobo? Not at this time.
Not at this time.
Good. General Langford?
Thank you, Your Honor. My name is Randy Langford, on behalf of the state, who's the defendant in this case, as you know, through Timms Ford State Park. We're going to request that the summary judgment of the Claims Commission be affirmed in this case for 2 reasons. First, the Claims Commission below offered 2 independent grounds for granting summary judgment. And only one of them has been appealed. So this court should affirm on the ground that was not appealed. Secondly, and this is the issue that Mr. Bobo spoke on, we would argue that the Claims Commission correctly and appropriately held that the recreational use statute does apply in this case and bars claimant's claim. So first, there were two independent grounds for the Claims Commission's grant of summary judgment. There was the recreational use statute, which we've talked about, and I'll speak more to today, but there was also an additional ground that was separate from recreational use. The defendant raised the defense of failure to state a claim because the claimant failed to allege an essential element of a claim for dangerous conditions on a state-controlled real property, which is one of the jurisdictional bases for Claims Commission's jurisdiction under TCA 98307A1C. And that essential element is notice. Both the statute and case law under premises liability requires that the defendant landowner have some type of notice prior to the injury in order to bring a claim under that statute and just generally in premises liability cases. So, and this court has held that if there are two independent grounds for a judgment and the claimant fails to appeal one of those grounds, then the remaining, then that ground should be affirmed. So
if we affirm that ground, does not that require affirmance of the Claims Commission's decision and renders the other issue moot?
I'm sorry, can you ask that question again, Your Honor?
If the Claims Commission or a trial court states two grounds for granting summary judgment, and the plaintiff only appeals one of them, then isn't the other ground for granting summary judgment for summary dismissal now a final judgment?
I would agree. To the extent that that is a judgment that is would dispose of the claim, I would agree that I think that's the effect that affirming.
The point is, if we are not asked to review the dangerous condition on state property ruling, and we find that we disagree with the trial court on the recreational use statute, aren't we still bound to affirm the Claims Commission dismissal of the claim?
I believe so. Yes, Your Honor.
Okay, proceed. Well, I'll ask Mr. Bobo that same question.
So that's the first reason that we believe the judgment should be affirmed. But secondly, as Mr. Bobo spoke on, and as has kind of been the primary issue in this case, is the application of the recreational use statute. As Mr. Bobo said, the initial application of the statute is not in question. There's analysis that you'll see in those cases that are part of the question of whether or not it should be raised in the first place. But here we've gotten to just whether or not one of these exceptions to its application should apply, which is this gross negligence exception. So the Claims Commission decided, and we would agree that the nature of what's being alleged by the claimant in this case does not rise to the level of gross negligence. As Mr. Bobo said, gross negligence is characterized by a callous disregard for the safety of people on your property, to be aware of some dangerous condition and to disregard that and to show a lack of care. Here we have plenty of facts in the record before this court showing that the park took efforts to monitor the playground, to maintain the playground as best it could to keep it safe. There's also nothing in the record showing, as Mr. Bobo said, that the park had knowledge of some kind of dangerous condition present on the playground there, either some specific defect or the knowledge that their typical practices for maintaining the playground were somehow deficient. And they would have known that through some prior injury or some complaint or a report that had been filed or brought to the park's attention. There was nothing there for them to disregard. So that knowledge aspect of it is something that the case law speaks to often. If you look at the other cases cited in the briefs, when gross negligence is found to be present, the defendants in every case knew of the danger and didn't do anything about it. But that's not the only part of what goes into that gross negligence consideration. There's also discussion in the case law of the severity, the degree of the danger that is posed by the defect that's on the property. You have things like live explosives in the Sumner case, or that rusty cable that was stretched across a path that motorcycles are driven on in the Rue Castle case that Mr. Bobo mentioned. We would argue that a thin layer of mulch, even assuming that there could have been more padding on the playground, we would argue that a lack of padding, a hardness of the ground does not come close to the degree of danger posed by the case law and things such as explosives, rusty cables where people are driving vehicles, things of that nature. So we would argue that the Claims Commission was correct that those two primary reasons show that gross negligence couldn't possibly be found in this case, and that's to say that there would be nothing for a reasonable fact finder to consider here because it's clear that gross negligence is not present. I would just add that, as Mr. Bobo mentioned, it's undisputed that there wasn't some kind of protruding concrete or rock or something that had no business being on a playground at the time that Layla fell, or in the specific area that claimant's daughter fell, that was involved in this injury in any way. So there would just really be nothing for the fact finder to consider in that regard.
Mr. Langford, not every accident involves negligence, does it? Sometimes things just happen.
I would agree with that, Your Honor. Based off of what I've said here today, I'd respectfully request that the court affirm the summary judgment by the Claims Commission. Thank you.
All right, thank you, sir. Mr. Bobo. Please unmute.
All right, I've got it. So,
Thank you.
Yes, and just to reiterate what I stated earlier, and our stance is that in hearing or the fact that there is hard pan or rock protruding, that would show a grossly negligent act in not maintaining the property correctly. We did not know whether they had notice prior to this. We do not. It was stated by the Rangers that they had never had another incident report or any other incident prior to ours. So our stance is one clearly that there is gross negligence here, and that is what resulted or what caused our accident. That's it.
All right, Mr. Bobo, did the trial court, the Claims Commission, grant summary judgment on two separate and independent grounds?
Yes, that was not grossly negligent, and claimant failed to allege that there was notice. So yes.
And the first pertains to the recreational use statute, and the second pertains to claims against the state regarding injuries on state-owned or managed property.
That's correct, Your Honor.
Okay, all right, thank you. Anything further? All right, hearing nothing. Thank you, Mr. Langford and Mr. Bobo, for your arguments. We'll take this matter under advisement. Mr. Hivner.
This honorable court is now adjourned.
All right, counsel, you are free to exit the meeting.
Thank you.
Thank you, Your Honor.